Welcome back to this channel. There is an important question that we need to examine, and that question is important because it has to do with the law. Can a court of law proceed to convict and sentence a defendant who pleads guilty to a particular charge without calling on the prosecution to prove the ingredients in the charge? Well, whether or not this can happen is what we'll come to, examine as we proceed in this video. Now, let's look at another important aspect of this discussion. There are several grounds that has been decided by the court that a court can decide to rely on in convicting a defendant. One of these grounds is eyewitness account. If there is a credible eyewitness that saw a particular incident happen, that credible eyewitness, unimpeachable eyewitness account can be used or based or a ground that the court can hold on to convict a particular defendant or accused. Another ground a court of law can use to convict a particular defendant or an accused person is the confessional statement made by the accused person. The confessional statement that is written by the accused person, usually at the prosecuting agency's facility. So it could be at the police, it could be at the DSS, that's the Department of State Services or State Security Service. It could be at the office of the ICPC, it could be at the office of the NSCDC. Any of the prosecuting agency that is prosecuting the defendant, the statement made at this facility can be used to convict the defendant once it is shown that the statement was made without duress, meaning that it was unequivocal, it was voluntarily made. That can be a ground, that can be an evidence, a piece of evidence that the court can use to convict a defendant or an accused person. Another ground or another, element or evidence the court can use to convict a defendant or an accused person is the circumstantial evidence. The circumstances surrounding a case can allow the court to reason, put 1 + 1 together and determine that indeed, if this could happen, this could happen. Oh, there's blood in your hand, there's a knife on the floor, there's blood on your clothes. It means that there's a dead person here, literally, and this dead person, the person died by stabbing. That could be a ground to say that, yes, well, there's no eyewitness account. Yes, there's no camera or video evidence to show. However, based on the circumstance of the case, we can point, directly and positively to the fact that this person or the accused person committed the offense. Now, let's look at whether or not a court of law can proceed to convict an accused person based solely on his or her confession of guilt or his or her admittance of guilt while at the dock, without calling on the prosecution to prove the charge or prove the ingredients in the charge beyond reasonable doubt. And this we'll see in the case of Idris against the state. The matter was decided in 2004 but reported in 2005. And this was an incident that happened in Bida in Niger State of Nigeria. Idris and his friend Garuba conspired and indeed committed the offense, the serious offense of rape of an 11-year-old girl. After the incident, the girl was taken to the hospital. A lot of tests was conducted and it was shown that there was an incident of forceful penetration, which could be a proof of rape. Idris and Garuba were timeously charged to court by the police. While in court, Idris was unable to secure the services of a legal practitioner for close to 10 months. Eventually, Idris was moved and his friend Garuba from Bida in Niger State to Minna, which is the state capital, precisely at the Chief Judge's court. And when the charges were read to Idris and Garuba, both of them pleaded guilty. And there and then, the court proceeded to convict and sentence both of them to 10 years imprisonment. Can we say that the decision of the court in this regard is based on law proper? Well, Garuba did not appeal. However, Idris appealed to the Court of Appeal, and he has several grounds of appeal. But one of them, which is very germane because of today's video, was the ground as to whether it was proper for the trial court to have convicted him, the trial court, which is the High Court now, to have convicted him based solely on the fact that he pleaded guilty without calling on the prosecution to prove the ingredients in the offense beyond reasonable doubt. Well, the decision of the court in this case is very germane. But before we move to the decision of this court, it's important that we remind you that this channel requires your support, and you can support this channel by subscribing to this channel. Click on the notification button when you subscribe so that you can be the first to enjoy any content that drops on this channel. Now let's look at the decision of the court. The decision of the court was that the responsibility, the onus of proof, always rests on the prosecution to prove the ingredients in every charge beyond reasonable doubt. And therefore, the court ought to have allowed the prosecution to approve the ingredients in the charge, which is the charge of rape. And because that was not done, Idris was set free and he was allowed to walk free. However, this is also understandable because it is said that once the defendant pleads guilty to a particular charge, the court can proceed to convict. Yes, especially if it is not a capital offense. But because this is not a capital offense, the court can then proceed to convict. However, the reasoning of the court in this case is that based on the ingredient for rape, which requires the proof of penetration and all the other ingredients to have been proved, the prosecution has a duty to have done that, which unfortunately was not done. And that was why, or one of the reasons for the quashing of the decision of the trial court. And then the court went on to allow Idris's appeal. Perhaps this will get to the Supreme Court so that the Supreme Court can lay to rest this particular decision of the Court of Appeal. Whether or not the Court of Appeal, my Lord Justices at the Court of Appeal were right or wrong, it's a decision for the Supreme Court to make. Well, I hope you've learned something in this channel. See you next time in our next video.